High Court today briefly heard the anticipatory bail application filed by Subhas Velinkar, and the court has allowed him to appear before the investigation officer at Bicholim police station at 5 o'clock today, 5 p.m. today. We have Advocate Waj, who has represented one of the intervener, Warren Alemao. Advocate Waj, what happened exactly when the matter came up for hearing today?
As you might have known, matter was first on board. It was the first matter which was on board. So in a sense, we might say that there is a lot of importance given to this matter even by the learned judiciary. And we had the learned PP who represented the state and represented the police, and also we had on Velinkar's side also we had the applicant, and what we saw is that the PP made most of the submissions. The interveners were allowed to intervene. The order has come that all the interveners, whoever want to intervene, are allowed to intervene. Now next the matter is kept on 15th of October for the report of the IO. So far, since there was a categorical statement from the accused that he is willing to surrender, actually that was the only course that was available to him. If he still continues to abscond, then he would not be entitled to any protection. Now he has made a categorical statement that he wants to surrender, and the court has allowed him to surrender. And as the statute also, which is your BNS, section 35 is there, which is the entire process for how arrest is to be made. So the court has said you comply with that process. Court has not separately said that we will give protection and not give protection, but court has said comply with that process, comply with the statute. PI also has to comply, IO, that is the investigating officer, has to comply, and accused also has to comply, that is accused has to give out the information as and when the police requires it. So in this sense, a peaceful atmosphere will be created, will be allowed, is fostered through the court's order today, and accused will also be able to join the investigation, and also the IO will not be burdened, will not be under pressure to conduct the investigation in a particular channel. I think it is a fair order.
But at the last, whatever I could hear, that public prosecutor has stated that they have not decided about the arrest or not. It will depend how Subhas Velinkar cooperates with the investigation. Even PP said that we are happy that if he joins the investigation, but we cannot rule out. It depends upon his cooperation. What exactly happened?
Yes, it does depend on his cooperation, because if he is asked certain things and he does not respond, does not reply, that means he is not joining the investigation. Joining the investigation does not simply mean that your 2 feet take you to the police station. It means that you have to, if they have asked you for some documents, you have to produce those documents. So in the course of this week, he will be asked many things to support whatever he's saying, and he will have to defend himself before the police. So if he does that effectively, if he joins the investigation in the true sense of joining the investigation in letter and spirit, then he will not be arrested so far as he is complying. If there is any kind of wriggling away from the investigation, then there will be grounds to arrest him.
You are counsel for the...
And importantly, it is not interim protection, if you see, because it is not that that the court has said don't arrest him. Court has refused to say don't arrest him. Correct. So that is there.
You have represented intervener who are asking for the arrest, whatever I feel. What is intervener's stand now when court has allowed him to appear before the IO?
No, intervener definitely respects what the Honorable Court has decided, and it is for the best interest of Goa also, because now that he is going to appear in a peaceful manner, we are also going to watch and whether for the next 1 week he is going to do a good job of the investigation, sorry, not good job of the investigation, but he is going to join the investigation, then we are also happy about that. Arrest means what? Arrest means that we want the entire matter to come out and we want him to be brought to books. So if he is going to be brought to book by way of a peaceful joining of the investigation, then that is also agreeable. No doubt he deserves to be arrested, but apart from that, legalities prevail and section 35 allows for arrest if he does not respect the IO.
So your stand is also similar on the line of investigation officer, that if he cooperates with the investigation, then there is no need of arrest, and if he doesn't, then definitely section 35 of BNSS will be followed.
See, I don't want to comment on the investigating officer because I have otherwise looked into this matter on the ground, and I found that Bicholi police, so I don't know whether it is the IO or the PI or any others, but I found that Bicholi police has been extremely lax in this matter. They will of course say no, they will deny what I'm saying. Not only lax, but I think they have purposely not made those attempts to arrest him in advance, and I think they are more than happy to have not arrested him all this while, and to not arrest him even now. Once he joins the investigation, we don't know, it is behind closed doors, so we don't know whether the IO is going to entertain him or he's actually going to take his work seriously. That I don't know, so I can't say I'm with the IO on that aspect. I'll say that I'm with the law on that aspect.
So thank you for talking to us. Again on Tuesday we will see that what happens in the matter. To sum up this matter, now I would say that when the hearing started, advocate representing Subhash Velinkar contended that since day one Subhash Velinkar wants to cooperate with the investigation, but he is fearing of arrest because there is huge public pressure. Then the court asked the IO and police that what is your stand about the arrest. Then public prosecutor on behalf of state, on behalf of Bicholim police, contended that we also want to serve him the notice first, but since day one he is absconding, he has not joined the investigation, and if he joins the investigation, then definitely it is duty of the investigation to follow Arnesh Kumar guidelines given by the Supreme Court, which says that just because the offence is non-billable or cognizable, accused should not be arrested automatically by default. It means that accused should be given chance to join the investigation. So PP was saying that because he is not cooperating and there is no other option but to arrest, to force him to join the investigation. Then the court said that okay, as the applicant here before the High Court, Subhash Velinkar, and accused in the matter, wants to join because his counsel is saying again and again that it is assured that he will not be arrested, then he will join the investigation. So on both sides, after hearing both the sides, the High Court has said that okay, let Subhash Velinkar appear before the IO today at 5 p.m. and then also given the chance to the investigation officer, to the police, that okay, you investigate as you want, and then a matter is fixed on Tuesday, and then police will have chance to say that whether Subhash Velinkar though appeared but cooperated with the investigation or not. But for now, court has allowed Subhash Velinkar to appear before IO, and there is instruction to follow Arnesh Kumar guidelines, which says that if punishment is below 7 years, then accused should not be arrested by default. There is some guidelines which has to be followed. Mukesh Kumar for Prudent.
कोर्टात आमी आसा आनी आतांच जजमेंट आयिल्लें आसा, ऑर्डर दिल्ली आसा दॅट तेका सुभाष वेलिंगकर म्हणटा तेका खंय इंटेरियम बेल ग्रांट केल्ली आसा. इंटेरियम बेल ग्रांट कित्याक केल्ली आसा कित्याक ही हेज अग्रीड इट सिम्स टू कम एंड कंप्लाय टू द कोर्ट. ही विल बी कमिंग इट सिम्स बिफोर 5 o'clock. तेका टायम दिल्लो आसा, तेणे येवचें आनी सरेंडर जावन तेणे कंप्लाय जावचें म्हणून. एनीवेज अदरवायज द मॅटर इज फिक्स्ड ऑन द 15th of October. हांव इतलेंच मागता बाब सुभाषा कडेन, सुभाष वेलिंगकर पुरो तुजी नाटकां 10 दीस जाल्या फ्रॉम फर्स्ट तुवें अटेरन्सीस केल्ले 10 तारखेर, आयज 10 तारखेर पावल्या. हांव ज्युडिशियरीक ब्लेम करना. ज्युडिशियरीन त्या दीस ताजी बेल सेशन एडिशनल सेशनाक रिजेक्ट केल्ली, पूण आयज जेन्ना तांचे हो सांगता, रिप्रेझेंटेटिव्ह सांगता की ही इज रेडी टू कंप्लाय विथ द कोर्ट एंड इज रेडी टू कम एंड सरेंडर एंड दिस थिंग, सो ही इज ऑब्वियसली इफ ही इज रेडी टू कॉपरेट देन दे हॅव टू नॉट रिजेक्ट हीज बेल. सो नाव आय एम आस्किंग सुभाष वेलिंगकर, आमकां इतलेंच जाय, तूं सुसेगाद VIP आसा, तुका सगळे यू हॅव गॉट ऑल द फॅसिलिटीज. वी हॅव बीन स्ट्रगलिंग ऑन द रोड. हांव पयले सुवातेर मागता म्हज्या गोंयकारां कडेन देव बरें करूं म्हणटा, म्हजे एक उल्याक तुमी आयले, my one call, all the Goa petle aile, but we had a peaceful and with a lot of harmony, we had the protest. But here I would like to say, it is not the judiciary. I have full faith in the judiciary, but somewhere the Goa government has failed and CM has failed big time. CM, you are the Home Minister. नोटीस दिवपाक लेट केले तेका FIR तेजे लॉन्च करपाक तुमी लेट केले आमी बोर्ड करता की रस्त्यार येता की तुमी FIR धाडली मागीर ताका अरेस्ट करपाक तुमच्यान जावना यू हॅव फेल्ड बिग टायम CM इट इज टायम I feel that no that it is not the mistake of judiciary or anybody I don't believe even the police it is you have to take the responsibility and you I feel that it's time I feel with heavy heart that you should give your resignation because कोणे कितें केल्यार आमी रस्तो आमचेर आतां FIR घातल्या इन दॅट मॅटर ऑन मी एंड 500 पीपल बट हाजेर एक्शन घेवपाक कितलो लेट जालो तो तुमी पळयल्लें आसा सो आय फील वी आर पीस अबायडिंग गोवन्स रिगार्डलेस ऑफ कास्ट एंड क्रीड एंड रिलीजन वी ऑल बिलीव इन गोंयचो साहेब सुभाष वेलिंगकर तुका हांगा हाडले जाल्यार एकूच माग तूं फक्त माफी माग गोंयकारां कडेन तूं सॉरी माग You just apology माग तू गोंयकारा कडेन that I've heard the sentiments of our Goans हांव आनी गोंयचे साहेबाच्या हेका हें करपाना आनी apology माग आनी मागीर कितें आसा तें तुजें जातलें देव बरें करूं.
We have counsel representing intervener Cruz Silva, advocate Amit Palekar. Sir, what happened today before the High Court?
See, when the matter came up for the hearing, we had filed intervention application on behalf of our MLA, MLA Cruz Silva. And when the matter came up, the statement made by the counsel for the petitioner, that is Velinkar, was that he will comply with the notice under Section 35, which was issued to him by Goa Police, and then he'll appear before the police. So there were various other questions which were asked by the Honourable Court, and one question was whether notice was served to him before anticipatory bail. I think there could not be sufficient reply to that from Bicholim police. Thereafter, another question was asked was whether after his non-compliance to the notice as per 35(6) of BNSS, whether any application has been filed before JMFC to seek his arrest, and that was not also done. So those lapses also meant that he could not be arrested because there was no compliances as per Section 35 by the police also to seek his arrest. And when he himself says that he'll appear before the court, he'll appear before the police. The police have said that they will not arrest him if he appears as per the notice, and that was what is the law is. So if going by the law also, it has been followed to the T right now in the High Court, and the matter is now posted for compliance by next week, next Tuesday, and we'll have to see what happens today after investigation is completed.
PP has said that let him appear before investigation officer, but it does not mean that appearing before the IO is the cooperation with the investigation. They said that let the matter fixed on Tuesday, and we will say that has he cooperated with the investigation or not. What law says in that scenario? I'm just simply asking the law point.
The law is very simple. First of all, compliance with the notice is mandatory when it is issued under Section 35, which was not done, which the learned district judge, the sessions judge, has considered that in spite of notices he did not appear. Now, once the anticipatory bail has been rejected, it was duty of the police to approach the JMFC under that particular section under 35(6) and ask for his arrest for the reasons to be recorded. Now that has not been done by police. Now here the question comes is, once he appears, his appearance is first thing is joining investigation. Thereafter, during the process of investigation, what will be the question that will be asked? What is the interrogation that is going to be conducted? It is something that is left with the police to ask. And how and what is the reason for inciting this violence is a question that needs to be probed by the police. Now it will be there for the police thereafter to find out and tell the court that if he is complied or with an investigation, that will have to be answered only by the police and nobody else, not the accused himself saying that I joined investigation, but what was the investigation and what was the cooperation which is accorded by the accused to the police in that particular case.
So now it is for sure that he will appear before the police today at 5 o'clock and as and when required between till Tuesday. What is going to be your stand in that scenario?
See, I am a lawyer, so I cannot talk beyond law. One thing I must tell you is that if a person under Section 35 is issued a notice and he complies with that particular notice, then there is no question of arrest as per law. But to appear before the police. So we don't find a reason why and who should have advised him not to appear before the police, and the matter would have been ended the day he would have surrendered to the police in terms of this notice. In fact, it has led to further protests in Goa, further communal divide in Goa, and probably that is what we smell as a larger conspiracy in terms of the entire spread of hatred between two religions, and that is why have erupted in Goa. So I think that needs to be investigated thoroughly, that whether